Okay, good morning, everyone. All right, in chambers, we went over a number of objections, and I made some rulings. So let's start with the defendant's objections to some of the exhibits that the state wanted to put in. Mr. Ng, did you want to address that?
Thank you, Your Honor. Mr. Gray and I had a chance to go over almost 400 exhibits over the weekend, and we raised objections to several of them for the court's review. I understand the court is making a ruling that some of the exhibits are admissible and some may not be, but we did make an objection to exhibits 3 and 4, 239, 240, 241, which are spark of life exhibits. We object to A, the spark of life testimony. We understand the case law, but we respectfully disagree with the Supreme Court's case law in that already only one photograph is necessary, and that's why we object to those. We also objected to...
Okay, let me put on the record what my ruling was on that. The state wanted to put in 5 spark of life photographs. Minnesota law, of course, allows for that. I decided that the state could put in 3 of them, not the 5.
We also made several objections, Your Honor, to the autopsy photographs and photographs of Mr. Wright's body at the scene. Those would be 41, 113, 120, 125, 175. It's our view that the photographs of a naked body of Mr. Wright were unnecessary to prove that he was shot by a pistol. In particular, some of the photographs with his eyes open are prejudicial and not terribly probative of the issue, which was his cause of death, which we're not disputing that it was caused by a gunshot wound. And we therefore objected to those exhibits.
Would the state like to put its position on the record?
Thank you, Your Honor. We understood the objections to be about certain photographs with the eyes being open. That is a condition of a dead body on occasion. The autopsy, of course, is very relevant to the issues in the case and all of the injuries, and it is simply a photograph of the accurate condition of the body at the time and necessary for the medical examiner's testimony about the cause of death. We therefore believe that the photographs are relevant and necessary, and we opposed on that basis.
All right, I overruled the defense objections to the autopsy photographs. It's necessary for purposes of describing the injuries. Mr. Ng?
We had another issue that I'd like to put on the record, Your Honor, the passenger of Mr. Wright will be testifying today. And the defense seeks to admit exhibit labeled 1004, which is a packet of Xanax tablets. And the purpose of our admissibility, or the reason for the admissibility of the evidence, is that what happened here is that during the stop, Mr. Wright handed a package of Xanax tablets to his passenger and told her to hide the tablets. She then hid the tablets in her perineum. She was taken to the hospital, and at the hospital, a detective from Brooklyn Center was made to sit with her, which is customary. And during her conversation with the passenger, she told the detective, Mona Pearson, that Mr. Wright had given her the pills and that she'd hidden the pills. We believe this evidence is relevant to show Mr. Wright's consciousness. I mean, is that term we're bandying about in the case, that he was about to flee, that he knew he had an arrest warrant, didn't want the pills to be found on him because once he was in the jail, they would be discovered. We believe this is probative evidence, and it is consistent with our cross-examination of the passenger. We also believe that her statements, the passenger statements, are against her own keen interest because these are Xanax tablets that are not prescribed to anybody and she should not have had. and therefore when she confessed to Mona Pearson, she was confessing against her own interests. So for all those reasons, we sought to introduce the evidence of this green photograph and also to cross-examine the passenger for it.
Would the state like to be heard on its position?
I do, Your Honor. Thank you. It's our position, well, first of all, that the exhibit marked 1004, if the court wants to receive that in the court file only to preserve for the record, should it become an issue on appeal, it should not be filed as a public document because it is not an exhibit in the trial. It's just for the appellate record. Secondly, Your Honor, the issue in this case, as you know, concerns the state of mind of Officer Potter when these acts were committed. This court has already ruled that evidence of drugs that were not known to Officer Potter is not admissible or relevant and certainly prejudicial. And that's exactly what this photograph and this line of inquiry is intended to do, is backdoor that through, to impugn Mr. Wright based on this sort of backdoor approach, and that's why it's being brought out now as well, I believe. So we asked the court to follow its previous ruling in its order of October 27, that this evidence is not relevant and is highly prejudicial and likely to mislead and confuse the jury. It simply has no relevance to Ms. Potter's actions. Any claim that it has some relevance to Mr. Wright's actions is technically, I think, irrelevant. His actions are caught on camera, and Officer Potter will presumably testify about why she did what she did, but certainly there's evidence of what happened. And so it's irrelevant for that issue, for that reason as well. So we understand the court is, well, I guess I'll just say we, on those bases, objected to it.
Okay. Yes, I rule that would not be admitted as evidence. We'll make it a court exhibit should the case be appealed. I previously ruled that any type of evidence with respect to bad behavior on the part of Mr. Wright would not be admissible unless Officer Potter was aware of it at the time of the incident. The key issue in this case was Ms. Potter's state of mind when this happened, and that the Xanax has nothing to do with that issue and would only serve to mislead or confuse the jury. Okay, were there others?
No, Your Honor, but to preserve the record, we will offer as a court exhibit 1004, and we also offer from yesterday court exhibit 1005, which is a photograph of Daunte Wright pointing a gun into a mirror. The court has ruled that we can't admit those. How would the court prefer that we file these? Would you prefer we file these under seal or provide them to you?
We'll make them a court exhibit, and you can provide them to Mr. Kramer.
Thank you.
Okay, were there other ones, Mr. Ng?
No, Your Honor.
Okay.
Your Honor,
Yes.
if I may briefly, with respect to the exhibit that has now been identified as Court Exhibit 1005, that was from our discussion, I believe, on Monday about an area of cross-examination that the defense wanted to go into, and the court had made a ruling at that time that that photograph would not be allowed. I can't remember if we made a record about this on Monday, but that's what the Court Exhibit 1005 is. And again, I would ask that that not be filed publicly, but made part of the court file for appellate review.
Right, we dealt with that yesterday, actually, but did not make a record of it. So that will not be admitted, but will be a court exhibit. Okay, anything further from the defense?
No, Your Honor.
Okay, is there anything from the state?
Your Honor, we did also deal with objections to Exhibits 29, 30, and 31, defense objections, and we would, I guess just while we're making these records, we might as well that those are, well, 29 is a short video of the passenger, and the other two are photographs of her injuries. The defense did object to those, and the court overruled the objections.
Yes, I'm going to allow the video of the passenger and the video showing her injuries, or the photograph. Okay,
Excuse me, Your Honor.
yes.
With respect to our, the state's objections to our exhibits, we also have the right under the Sixth Amendment to present a defense. And I want to raise that as an issue for appeal if we go there.
Okay,
So we're being denied by the not being able to use these exhibits to present a defense under the Sixth Amendment to the United States Constitution. Thank you.
And, Your Honor, it's well-known case law that while they have a defendant has a Sixth Amendment right to defend himself, they have to do so within the rules of evidence that this court and courts adopt. So it's not a free-form right, but I understand the counsel's preserving that for the record. But that's the full story.
okay. Is there anything further that we need to deal with before we get the jury in here?
Your Honor, we did raise two matters in chambers, and I would like to make a quick record of it if I could.
Sure.
So we had raised a concern that counsel might represent to the jury that if, that the state has to prove Ms. Potter did not, too many double negatives, that the state has to prove Ms. Potter knew she had a handgun in her hand. And if the state can prove that, she is not guilty. We think that's a misstatement of the law, and therefore saying that to the jury would be a misstatement of law to them, inconsistent with the court's own instructions. And we brought that up ahead of time because we didn't want to interrupt for the first time bringing it to the court for an objection. And our understanding of the court's position on this is that the defense can argue that as a theory, as a factual theory, but we will take issue and argue to the jury that that is an incorrect, if it's stated in those absolute terms, that we will dispute that with the jury and, of course, direct them to the court's instructions, which will be an accurate statement of the law. And I don't know if you want me to move on to the next one or...
Okay. I had ruled that the defense is entitled to argue its theory of the case. And the state and the defense both have conflicting views of what their theories are, but I'm not going to constrain the defense from making their arguments. And they, in fact, do have an expert that's going to talk about slip and capture. So, and I've previously ruled that that expert testimony is admissible. Okay, anything further? All right.
Your Honor,
Yes?
we did talk about also the attempts by the defense to offer expert opinions, or what amounted to expert opinions, on the reasonable use of force through fact witnesses. Our understanding of the court's ruling is that the court will allow some inquiry about officers' opinions about whether their training would have allowed them to do what Ms. Potter did, I guess. So we're still, we still take objection to that, Your Honor, as both unqualified and unnoticed expert opinion.
Okay, the officers that will be testifying can testify that they were trained on the use of tasers. They can talk about their training. They are officers and they know about that area, and so I'm not going to preclude them from making those statements when they testify. Okay, anything further from the state?
No, Your Honor, thank you.
Anything further from the defense? Okay. Is counsel ready for the jury?
Your Honor, we would request a short recess.
Oh, okay. How short a recess?
We just need the setup, Your Honor.
Okay. Why don't we take like 5 minutes? Would that be enough? Okay, we'll take 5. Mhm. Yes, I'm ready for the jury. Good morning, members of the jury. Please be seated. All right. Jury members, you've been selected to serve as the jury in this case. Before continuing with the trial, an oath will be administered by my clerk. In recognition of the extremely important task that you will be undertaking, I'm going to ask that everyone in the courtroom stand up, with the exception of the court reporter. And if you will please stand up and raise your right hand.
Do you affirm that you will be attentive during this trial and follow the instructions of the judge so that you may reach a fair and just verdict, that you will not discuss this case with anyone until submitted to you for deliberation, and will keep your verdict secret until it is delivered to the court? If so, please say I do.
All right, you may be seated. Jury members, you have been selected to serve in this criminal case because the parties believe that you would be fair and impartial jurors to decide this case. It is important that you be able to hear and see everything that takes place during the trial. If you have difficulty hearing or understanding what a witness is saying, or if a witness or an attorney should block your view, please raise your hand immediately so that we can correct the problem. The state of Minnesota has charged this defendant with the crime of manslaughter in the first degree and manslaughter in the second degree. To these charges, Ms. Potter has entered a plea of not guilty. By her plea, the defendant denies the charges which have been made against her and places upon the state of Minnesota the burden of proving defendant's guilt beyond a reasonable doubt. The defendant is presumed innocent of the charges made. This presumption remains with the defendant unless and until the defendant has been proven guilty beyond a reasonable doubt. That the defendant has been brought before the court by the ordinary processes of the law and is on trial should not be considered by you as in any way suggesting guilt. The burden of proving guilt is on the state. The defendant does not have to prove her innocence. Proof beyond a reasonable doubt is such proof as ordinarily prudent men and women would act upon in their most important affairs. A reasonable doubt is a doubt based upon reason and common sense. It does not mean a fanciful or capricious doubt, nor does it mean beyond all possibility of doubt. The trial in this case is about to begin. Here are some basic rules about your job as a juror. Your job will be to decide what the facts are in this case by considering the evidence. As judge, I will apply the rules of evidence and tell you what you can and cannot consider as evidence. Well, what is evidence? Evidence is what the witnesses say on the stand. This is called testimony. Evidence can be items like photographs and documents. These items are called exhibits. Evidence can be facts that the parties agree on. This agreement is called a stipulation. What is not evidence? The following is not evidence. Nothing the attorneys say during the trial, including opening statements and closing arguments, is evidence. However, listen to any statements the attorneys make. The statements are made to help you better understand the evidence. The attorney's questions are not evidence. The witness's answers are. Objections are not evidence. Attorneys may object if they think a question or answer is against the rules. I will sustain the objection if I think it is against the rules and you should ignore this question or answer. If I overrule the objection, the answer is evidence like the rest of the witness's testimony. You cannot consider anything you hear or learn about this case outside this courtroom. You must follow the instructions on what you can consider as evidence. You may take notes during the trial, but you do not have to take but you're not required to take notes. Don't let your note-taking distract you. The most important thing for you to do is to listen to the testimony as you hear it. The notes must stay in the courtroom during the trial. You should leave your pen and your notepads on your desks. They'll be there in the morning when you come back and after you come back from lunch. Use your notes as an aid to your memory and not as a substitute for it. Fit the notes in with your total recollection of the facts. A written note does not necessarily make a piece of evidence more important whether you or another juror wrote it down. If at some point in the trial you run out of paper or your pen is no longer working, please alert my staff and we'll take care of that. Wait until you've heard all of the evidence before you make up your mind. Your best guide is your own good judgment, experience, and common sense. You must decide which testimony to believe and how much weight to give it. In deciding this, you may consider the following. Will a witness gain or lose anything if the case is decided a certain way? What is the witness's relationship to the parties? How did a witness learn the facts? How did she or he know, remember, and tell the facts? What was his or her manner? What was his or her age or experience? Does the witness seem honest and sincere? Was the witness frank and direct? Is the testimony reasonable compared with other evidence? And are there any other factors that bear on believability and weight? You must decide the facts. You and only you can decide the facts. Do not take anything I say or do as a sign of what your verdict should be. Once the facts are decided, you must follow the law. You must follow the law even if you don't agree with it. Now, I want to give you a few instructions about your conduct as jurors. Do not let outsiders influence you. Do not discuss this case with other jury members during the trial. You will have plenty of time to do this at the end of the trial once you have heard all the evidence and I've excused you to the jury room with my instructions and the verdict forms. Do not talk to anyone involved in this case. This includes the defendant, the lawyers, and the witnesses. If anyone tries to discuss this case with you outside the courtroom, report this to me or one of my staff. When you go home during the trial, do not talk to your family, friends, or others about the case. You may tell them that you are a juror on a criminal case, and that is all that you should tell them. Do not report your experiences as a juror while the trial and deliberations are going on. Do not email, blog, tweet, text, or post anything to Twitter, Facebook, MySpace, LinkedIn, Google+, YouTube, or any other social networking sites about this trial. Do not visit any chat rooms where this case may be discussed. Do not read or listen to news reports in magazines or in newspapers or on the radio, television, podcasts, or any other media about the case. Do not do your own investigation. Don't ask people about the case. Don't visit any of the locations mentioned in the trial. Do not research anything about the case, including the issues, evidence, parties, witnesses, location, or the law through any form of written, print, electronic, or internet media. Keep an open mind until you have heard and seen all the evidence. Remember, you cannot consider anything you hear or learn about this case outside this courtroom. If you don't follow these instructions, you may jeopardize the trial. This may require that we start all over again, and we really don't want to do that. If you become aware that another juror may have violated these rules, you must report it to me or one of my staff. I know that this can be a difficult thing to do, but in order to preserve the fairness that is guaranteed to everyone involved, it is very important that you do so. Please take note of the chair you are sitting in and keep the same chair throughout the trial. When reporting for jury duty in the morning and returning to the courthouse after lunch, you you need to report to the courtroom waiting room that you were in today. Do not communicate with anyone in the hallway if you happen to be out there who is not a member of this jury about any matter. These rules will apply until I dismiss you from the case. I may also repeat these rules when we take a break and when you leave at the end of the day. I don't do this to insult you, but in this age of electronic communication, it's a natural impulse for us to all look things up, to discuss things that we're doing with our friends and family, and post things on the internet. It is not, however, an impulse we can follow in this trial. Once we've completed this trial and you've given your verdict, and I have discharged you from the case, you will be free to do any research you choose and to share your experiences if you choose to do so. If you have a question I want to remind you again, you want to communicate with the court, please alert my staff. During the trial, of course, if you have any difficulty seeing or hearing, please raise your hand or make my staff aware of that. I will be instructing you on the law more fully after the testimony has been completed. I want to give you a broad outline of what this trial will look like. First of all, the attorneys will be making their opening statements. The purpose of the opening statement is not to argue about the evidence. The attorney's goal is just to give you a bird's eye view of what that attorney believes the evidence will show. After opening statements, the state is going to proceed first with its case in chief. After each state witness is called, the defense has a right to cross-examine. After all state's witnesses are called, the defense has the right to call witnesses as well, and the state has a right to cross-examine defense witnesses. Remember that the defendant is not required to prove her innocence. She is not required to call any witnesses. After the defense has called its witnesses, I will be giving you, the state may have rebuttal witnesses, and then I will give you your instructions of law that you are to apply in rendering your verdict. Following that, the attorneys will make their final arguments to you. Okay. Would the state like to proceed with this opening statement?
Yes, Your Honor, thank you. Police officers occupy unique positions of power and responsibility in our society. They hold positions of public trust, and they commit themselves to public service. They are accountable to the communities that they serve. And Brooklyn Center police officers are no exception. Their fundamental duty is to protect the sanctity of life. To do this job, the job of a Brooklyn Center police officer, they promise to safeguard lives. They promise to serve and protect, to maintain calm and develop self-restraint, and to be constantly mindful of the welfare of others. They promise never to employ unnecessary force or abuse. This is the oath of a Brooklyn Center police officer. I will never betray my badge, my integrity, my character, or the public interest. I will always have the courage to hold myself and others accountable for our actions. This is the standard they hold themselves to, and they take an oath to do so. Their duty to their badge and to the community is to protect life, not to take life. Now, they are also required to abide by a code of ethics. This serves as a type of compact or an agreement between each of the officers and the public that they serve. It sets forth what the community, what the public should expect from each and every one of them. It affirms that the badge is a symbol of public faith and public trust, and that the officers are each individually responsible for their own professional performance. And they each vow to take every opportunity to enhance and improve the level of their knowledge and competence. These officers carry deadly weapons every day on the job, and they receive extensive training in order to carry them. They're trained professionals. They're entrusted by the public with these weapons. Every day they put on their uniforms and they go to work, and they